And Your Honor, I'll have one witness. She's logged in now with her audio and video muted. It's Miss Patricia Ford.
Miss Patricia who?
Ford, Your Honor, F-O-R-D.
I'm trying to see if I can find her.
Judge, can we put something on the record, please?
Hold on one second. Let me see if I can find her to begin with, okay?
Your Honor, her box is next to Mr. Farley's, actually, coincidentally,
I'm going to move her.
to the right.
Now I see her. Okay. Ms. Ford, can you turn your camera on for me, please, madam? Okay. Mr. Geary, you want to say something, sir?
Yes, sir. I just want to put on the record, Judge. We were told that this bond hearing would not be on the calendar. We would announce not ready. We will follow the court's instructions.
Your Honor, this was on the calendar that was mailed out to us, and it says on there, motion to reconsider bond.
Mr. Geary, I'm going to go forward and it's a motion to reconsider bond. So tell me what's changed since the last time that I considered bond for you, or for your client, I should say.
Yes, thank you, Your Honor, for the opportunity. There's a lot that's changed.
Because I denied him bond back in May the 23rd of this year.
That's correct, Your Honor. That's right.
All right.
That was all based on proffers made by the state and the defense before discovery had ever been sent out. And so, Your Honor, I do want to correct several misstatements that the state made about Mr. Farley at that prior hearing, so that the court now has a more nuanced, full picture of things to take into consideration with the other things presented, as well as the Ayala factors, Your Honor. There was a lot of proffers about the murder count that Mr. Farley is alleged to be a party to. We've since gotten the discovery. The warrant affidavit itself alleges no party to a crime allegation whatsoever. It alleges just mere presence and mere association, Judge. And I've now done a little investigation into Mr. Farley's clothing company, which is what brought him into all this in the first place, Judge. And so I do want the court to consider that together with some proffers. And I understand the state's position about the privacy of the discovery and that they have a pending motion about us not sharing discovery outside of our legal staff. And I would also, for the record, they have made some implications about the defense counsels in this case, yet they're using Dropbox, which is a private third-party company. So it's entirely possible that someone within their office or someone within Dropbox has connections to social media and, you know, TMZ and stuff like that. So I would ask, Judge, if we could do an in-camera inspection of some very small portions of the discovery, specifically the BP video that the state referenced earlier at the prior bond hearing.
Did you put that in your motion?
No, Judge, I didn't.
Okay, so I'm going to take up that on the 8th. So if you want to proffer or have me consider that, file a motion. And I'd invite you to put some suitable facts and law in there like you're doing right now, and have me consider it and have the state respond to it, okay?
Yes, Judge, and may I continue?
Yes, you may. Go ahead.
Yes, so in the case that bond is denied today, Judge, I will return on the 8th with that in-camera motion. But for now, Judge, I'll proffer what I find different to the state, Judge. For one, the state implied at the prior hearing that Mr. Farley knew these people very intimately, that he greeted them when they walked into the BP. But, Your Honor, what actually happened is there's a Fusion and an Audi. The Audi is alleged to have Mr. Shannon Stillwell in it. The Fusion is alleged to have Mr. Quamarvius Nichols and Mr. Farley in the back seat with Quamarvius driving. And so the Audi and the Fusion are at this gas station right around from the juvenile court, Your Honor. And then the deceased pulls up in a car, and when that deceased leaves, the Audi follows him and the Fusion follows him with Miles in the back seat of the Fusion. The license plate readers confirm that the Audi is in front of the car that Mr. Miles Farley is in the back seat of. And Your Honor, it's this mere association with Mr. Comarvius that led him to be there. He's not even a driver of one of the cars. And he doesn't actually greet anyone when he walks into the BP. Mr. Stillwell and Mr. Nichols are standing at the cashier, doing something playful with the cashier. And Mr. Farley later gets out of his car from the back seat, walks into the store by himself, and doesn't acknowledge Mr. Stillwell or Mr. Nichols. And as he's walking by to get something, Mr. Stillwell turns and does this playful, bucking kind of playful thing and startles Mr. Farley, who then playfully turns around and continues to go into the store. And then out of the corner of Mr. Farley's eye, he sees Mr. Stillwell and Mr. Nichols about to just leave him there. And so he, in a panic, scurries away, follows them out the door. They don't even acknowledge him any further. They turn his back on him and they leave, Your Honor. So the association and the presence here has more nuance to it than the state alleged at their proffer, Judge. And so what I contend to this court is it's corroboration of what I presented to the court initially, that Mr. Farley, he's a graduate of South Atlanta High School and Miles University, and all this time at 24 years old, has never been convicted of anything besides a misdemeanor amount of marijuana at some point, Judge, which is a typical teenager, childish thing. So, Your Honor, he has no criminal history. He's an entrepreneur with a business degree, and his specialty is he makes clothing. The company is called Make America Slime Again. It's a play on words. In the hip-hop industry, there's a lot of this. You put the word trap or slime into something that's already part of pop culture. It's just good business, Judge. It's something people already recognize. It's something that's kind of humorous. And this is one of the shirts, Judge, I have for you to see. This was a new shirt after Make America Slime Again off of the Trump logo or slogan. Now there was Keep America Slime. So all it is, Judge, is these hats and shirts that took the Trump merchandise, replaced it with this word slime, which is not always criminal. And like every word, and especially that word, it's context dependent. It's like the word dude. It depends who's saying it, when are they saying it, who are they saying it to, why. You could be my dude, you could step on my shoes, and I could be like, dude, what was that? You could be that dude. There's so many things. So slime on its own means nothing because it can mean so many things depending on the context. So that's all he's doing, Judge. He's making these clothes. He sees a business opportunity. He's friends with Mr. Wunny Lee, who's the creator of the hip-hop persona Slime Life Shorty. And as his friend, he becomes his personal assistant to make sure he gets to music videos on time, stuff like that. He's actually paid by the label that's not even YSL. And then, Judge, he's using the proximity to celebrity to take advantage of just attention, which is a top commodity these days, name recognition, product placement, to have his hoodies and his shirts in these music videos worn by these artists is a way to make money. And he's born and actually raised on Cleveland. It's not just a tattoo. He's raised on Cleveland Avenue. His dad's also an entrepreneur. They call that area Little Haiti because there's not a lot around, so you have to be an entrepreneur. So here we have a young man, college educated, never been arrested for a felony, and he's making his clothes, and instead of sitting there and maybe, selling them on the street next to the people, doing the lamb chops or selling the Powerades, he has this brilliant idea to go on tour with Mr. Wunny Lee and sell to fish in a barrel these suburban kids that go to these concerts. And I can proffer, Judge, as an officer to the court, I remember what that environment was like, back in 2008, going to University of Michigan, go to the Kid Cudi concert, buy the t-shirt. And I almost want to say that I do remember there was a shirt where they had Kid Cudi as the Obama campaign thing at the time. So similar to what's going on here, Judge. It's like a deja vu. And so I admire Mr. Farley. He's very smart. He's well educated, and he found an opportunity to make this clothing. And then the state, because he's wearing this shirt that says slime or die, again, a play on words, if Your Honor remembers the Get Out the Vote campaign, Vote or Die. I think it might have been P. Diddy or some people at the time were pushing that. Again, Judge, just artistic play on words, proximity to other artists who are in music instead of clothing, and that's all this is, Judge. So on the Ayala factors, he hasn't ever threatened to tamper with any witnesses whatsoever. He's barely in any of the discovery. This 5 terabytes, it's not even everything, but he's barely in it, Judge. He pops up on the scene because he returns home after going to college instead of going out of state. And, I admire him for that. He's a family-oriented person. He has a child. The mother of his child helps him with the clothing company, Your Honor. And his father still stays there in the barbershop on Cleveland Avenue. And so I just don't see now, with having the discovery and knowing more about the clothing line, how we can deny Mr. Farley's bond. He can't be considered any risk, let alone a significant risk of reoffending, because he's never even been accused of a felony besides this. And the warrant affidavit itself, to this day, along with the discovery, alleges no assistance or any of the other 5 ways that you can commit a party to a crime, in addition to being the principal. It does not say that. It just says that he was driven somewhere by Marvius, gets out of the back seat, gets back in the back seat, and then the car is behind a car that's alleged to be involved in a shooting, and we don't even know the circumstances of that shooting. It doesn't even seem planned. It doesn't seem to be connected to anyone the way the other murders are alleged to be connected, Judge. And so he can't be considered a significant risk to reoffend. He can't be considered a danger to the community. He's college educated with no criminal history. He can't be considered a flight risk. He's cooperative the entire time. He is arrested without incident, without flight, no attempts of flight. He's had his communications monitored this entire time. I know that the Fulton jail even has voice recognition that knows when people are using other people's phones. He's not anything like that either. And so, Your Honor, the state does allege that he's present at a public forum, a public hearing with Mr. Wani Lee at some point. But again, Judge, he's his personal assistant. And all that the discovery alleges is that Mr. Farley told him where the courtroom was. There's no threatening, there's no witness intimidation, Judge. His communication has been monitored this entire time at the jail, and he just can't be considered a risk for any of the IL factors. And so, Your Honor, we just asked for their bond to be set in a reasonable amount, given the severity of the charges, to add some harsh conditions. I propose for the court a bond of $100,000, that he stay at the address that we provided to the court at the prior hearing, 2894 Browns Mill Road in Atlanta, Georgia, zip code 30354, and that we put him under the highest pretrial level of supervision and a 24/7 house arrest, and even take away his internet access. He can conduct his business through assistance without having to actually access the internet himself, Judge. That way, there can't be any worry about him contacting any witnesses or anything like that. And so, Judge, I do want to call Miss Patricia Ford very briefly to say a few words about Miles. She's his high school principal. She knows him very intimately over several years, and she can speak as well to the IL factors, Your Honor. So I would want to briefly call her and then allow the state to respond.
All right, Ms. Ford, can you unmute yourself, please? Ms. Ford, can you unmute yourself, please?
Yes, good afternoon.
Madam, can you hear me?
Yes, I can.
You're gonna have to speak up just a little bit. I'm gonna administer an oath to you, okay?
Okay, that's
Can you
fine.
raise your right hand for me, please? Do you solemnly swear or affirm the evidence you'll give in the matter now in hearing should be the truth, the whole truth, and nothing but the truth? So help you God or so affirm?
Yes, I do.
Okay, you can put your hand down, and you have to speak up. Use your outside voice.
So my name is Patricia Ford. I was Miles' principal for 4 years. Miles, he was my student. He was like my son. Everyone knew Miles was my student. And if Miles didn't do his homework or he just didn't do anything on task academically, they would bring Miles to me and I would just address Miles like he was my child. Everyone knows the love that I have for Miles. He performed well academically. He's a short kid by stature, but just a mighty soul and a mighty person, a lovable young man who went off to do great things after leaving South Atlanta High School. And so as a school, we all know Miles, we love Miles, and have just been taken aback by what he's being accused of just because of his disposition and demeanor that he portrayed and demonstrated while at South Atlanta. Never got into any trouble while at South Atlanta. He may have gotten into something his senior year for horse playing. He is known for just being a jokester and horse playing at school, but getting into fights never happened at South Atlanta High School. Not in my 4 years of knowing him. Just an overall good kid.
All right. Thank you, ma'am. And just to be clear, you were the principal. Was Miles ever accused of any kind of misconduct or suspended from school or anything like that besides the horseplay that you mentioned?
Nope, not at all.
Okay. And did you stay in touch with Miles after you graduated?
Yes, we did. He would come by the school when he was on vacation from school. He would always talk to another staff member at school, and I would keep up with him through her.
Okay, and as a principal, do you sometimes have a sense when you're observing these students in their formative years, which students might get into trouble in the future and which you feel like, no way, that's going to happen? Okay, and
Yes.
which of those buckets did Mr. Miles Farley fall into? Your discretion as a principal?
This would be the one that would never get in trouble. Because of his home bringing by his parents, he was just like a good kid, like we would say, just raised the right way. So just knowing that he's caught up in this is just taking many of us aback at the school who are still there and who knows Miles.
All right, thank you, ma'am. And then if he requires any of your assistance while he's being supervised and released on bond, would you be there for him to support?
Absolutely.
All right, thank you, Ms. Ford. Those are all my questions.
State, have any questions of Ms. Ford? Okay, all right, Ms. Ford, thank you very much. I'm gonna put you back on mute. You can be excused to go back to your usual duties and avocation, okay?
Thank you.
All right, thank you much, ma'am.
Bye-bye.
And, Your Honor, that's all I have at this time, except for a brief opportunity to respond to anything that the state might say.
Okay, what says the state? Go ahead, Mr. Geary.
I'll just do it from here.
You can sit or stand, sir, whatever your pleasure. I know we've been here a while, and it's about time for me to take a break, so.
No problem, Judge. Judge, contrary to what counsel just indicated, there is actually nothing new from the bond hearing from the 25-23, Judge. On that date, and what counsel wanted to do was argue the sufficiency of the evidence at trial, which is again not what bond is about. Understand he's presumed innocent, but we have the evidence. We've got the videos. We've got all the evidence there. Further, if we want to talk about the evidence respectfully, Mr. Farley instructed his girlfriend and or baby mother to dispose of a phone and dispose of a gun before we could get there. She didn't. We got it. So that's there. We've got Instagram posts by Mr. Farley basically saying forever homicide. Now, that's not a clothing. That's in line with YSL gang, with other gang members. You know, he's got the tattoos. He can't hang around YSLs and falsely claim. He's got them, the tattoos, and he's hanging with other YSL members. So he's not falsely represented. He's in the video. He wants to say he's Mr. Lee's assistant. He's in the video throwing gang signs, armed with a weapon. I'm not sure if that's in his job description as an assistant. He is seen numerous times on Cleveland. They say he's raised on Cleveland. Raised on Cleveland is the name of the predecessor gang to YSL. That is a street gang. And people want to just say, oh, I was raised on Cleveland. That's a gang identifier, Judge. Slam or die. He would be the first criminal to try to make $1. Judge, the fact that he might have a clothing line on theirs, and I will say that for Mr. Williams also. Mr. Williams has made an interview that stated the gang pre-existed the record label. It pre-existed the clothing line. That's a recorded statement by him. So anything that's marketing after that is an opportunity. I'm not saying they're not taking advantage of that. That doesn't mean they're not committing the original crimes. So just the fact that he is trying to make money off of selling something that is gang-related, that has got nothing to do whether he would commit offense. And I say this kind of left-handed respectfully. I know counsel didn't make an admission here, but he states the recording does show he's there on the scene at the time of the murder. It does. And it shows a lot more than that, Judge. He characterized the recordings. It's going to be for the jury to determine that. Judge, this is basically the same thing was presented to you on 523. You found false factors. There's no reason, there's no evidence presented to change that ruling, Judge. We ask you to deny.
Okay, all right.
Yes, Your Honor.
You got a minute?
Yes, just a minute, Judge. I agree with a lot of what the state said. Yeah, making a clothing line and using artistic content doesn't connect you to crime and make you a criminal, just like wearing a Scarface shirt or a Godfather shirt doesn't make you part of the mafia. It's art. What Mr. Williams is making is art. It's spread all over the world, and now Mr. Farley is a bystander, Judge. What the state didn't correct was that, yeah, he's on the BP video, not doing the things that the state proffered he was doing at the original bond hearing, Your Honor. We didn't have any of the discovery at that time. And this hashtag YSL, I mean, the word slime isn't even originated in Atlanta, Your Honor, as far as I know. I went around on the internet a little bit. There's a mixtape by VOD up in New York in 2009. It's called Slime Flu 2. And that predates a lot of this. So I think they're trying to just take advantage of this cultural term. Again, slime or die. It's just a play on words from vote or die, Your Honor. And it has nothing to do with whether or not someone's committed a crime. That's done through evidence. And the state still has not proffered anything beyond mere presence and mere association. The Forever Homicide, Your Honor, that's a song by Mr. Wani Lee, performed by the character Slime Life Shorty, where it's a play on words of homicide and homicide. I'm always by my homie's side, and it's just a little play on words with the word homicide. Mr. Farley, you heard from his principal, has never even been violent at school. Gang behavior begins sometimes at 12 years old, 13 years old. This is so out of the ordinary as an allegation. Who joins a gang when they're 24 years old and never even got in a fight at school, and yet they're a homicidal person that can't even get a bond when they're presumed innocent? So, Your Honor, this YSL has been hashtagged over 21 million times all time in Instagram. And so because Mr. Farley has a page that also has T.I. and Future on it, wearing his hats in addition to Mr. Williams, it's just not, there's still nothing now that we have the discovery, and now we also have an actual live witness, Ms. Ford, to correct the misstatements of the state in the prior bond hearing. And it's clear now that Mr. Farley is not a significant risk in any of the IL factors, and there are ways to mitigate these baseless allegations of witness tampering that he has nothing to do with and has been reported all this time. And if they have his phones and they have these incriminating things, and yet that's all they can still proffer, Your Honor, he definitely deserves a bond. It's just the conditions are at issue now, and we're willing to submit to any conditions from this court whatsoever, Your Honor.
All right, thank you, sir. All right, Mr. Menendez and Mr. Geary and Mr. Farley. I've had an opportunity to reconsider the what has been proffered in this particular from the 523 hearing in this case. Mr. Menendez, I don't find any change in circumstances. I do agree with the state in this particular situation. At a minimum, your client still poses a threat to persons and property in the community and poses a threat to intimidate witnesses or otherwise obstruct administration of justice. So I'm going to deny bond at this point in time. He's still on trial for the 9th of January of 2023. And if you file any other motions, let me know, and we'll go ahead and hear those expeditiously, okay?
All right, thank you, Your Honor. Good to see you.
Can we arraign him since we've got counsel?
Yes, Mr. Farley and Mr. Menendez, since you are here and the new indictment has in fact come out, Mr. Menendez, would you like to go ahead and have me arraign your client on the re-indictment?
Yes, Your Honor, that's fine. I went ahead and filed a packet of consolidated motions.
Okay.
And all I can think of now is that in light of the bond denial, I do intend to join in Mr. Steele's speedy trial motion.
We'll file it, and we will move on it accordingly. But in terms of the indictment, 22 SC 183572, is it your desire to waive formal arraignment on behalf of your client?
Yes, Your
Otherwise,
Honor.
have the court enter a not guilty plea on behalf of your client, and for you to have at least 10 days upon the receipt of discovery to file any motions?
Yes, Judge, we waive formal arraignment, plead not guilty, and we would ask that in light of the massive amount of discovery and the several co-defendants that we be allowed 60 days till after the completion of discovery to particularize or file any.
I'll give you 30.
Okay.
Because I'm still planning on moving on this case on the 9th of January. So, and I believe you've been given some discovery already, correct? So this is just the updated discovery. They just re-indicted to you know, for other reasons, but, I'll give you 30 additional days, okay?
All right, thank you, Judge.
All right, then, and then it'll remain on the 9 January 2023 calendar, okay?
Understood.
All right, thank you very much, sir.
All right, I'll see you on the 8th.
All right, okay. All right, Mr. Farley, you can be excused at this point in time, sir. Thank you.